Hello, am I audible? Sitara, are you there?
Sir, am I audible?
Yes, you are audible, but not visible. So please check your.
Good evening, sir.
Yes, I could even. Thank you. Let me check out just a moment. Hello, good evening, Ankit. Welcome.
Good evening, sir.
Good evening, welcome. Thank you.
Hope
Thank
you're
you for
doing well,
joining.
sir.
Thank you. Thanks for joining. So we'll be starting in 2-3 minutes. People are joining.
Sure, sir. Sure, sir.
Sure, definitely. So
Yeah.
we have Sitara, student coordinator from Gujarat National Law University. So she will be introducing you, and then we'll start.
Noted, sir. Thank you.
Okay, shall we start?
Yes, sir. Whenever you're ready, sir.
Sure. Sitara, over to you.
Good evening, everyone. I am Sitara V. Fatima, a second-year law student at GNLU. As the moderator, I warmly welcome you all to the 12th day of the 5th edition of the short-term course on legal aid and allied laws, organized by Pro Bono Club India in collaboration with the Pro Bono Club GNLU Gandhinagar. Today, we focus on an essential aspect of justice, the rights of victims, which is crucial in ensuring a fair legal system that acknowledges and addresses the needs of those affected by crime. It is my pleasure to introduce our esteemed guest, Mr. Ankit Kauhsik. He is a distinguished expert in the field of criminal law and victimology. Sir is a graduate of NLUJ, and he pursued his LLM from NLUD Delhi, specializing in criminal law and constitutional law. With a strong academic and research background, Sir has made significant contribution to legal scholarship. He has played a key role in the Committee for Reforms in Criminal Law. With extensive publications, research papers, and policy contributions in criminal law and constitutional law, Sir continues to be a leading voice in the field. Today, Sir will be enlightening us on the theoretical aspects of victims' rights, helping us develop a deeper understanding of crime and its impact on victims. His insights will be invaluable in broadening our perspectives on the legal and social frameworks designed to protect and empower the victims of crime. We are honored to have you with us today, sir. With this, I now invite Mr. Ankit Kauhsik, sir, to take over the session. Sir, please.
Okay. Thank you so much for that very kind introduction, Sitara. Very good evening to all. And at the outset, I would like to thank Professor Kalpeshwar Gupta at Pro Bono India and GNLU Gandhinagar, very specifically for inviting me to speak at the 5th edition of this course. And in particular on this very pertinent topic concerning what are the theoretical aspects of crimes vis-a-vis the victims. So the scope of this topic itself is huge, and to be fair, it usually takes me about a semester to get all my points across, right, with respect to this topic to the students. So restraining myself to an hour is certainly a challenge. Nevertheless, I'll try my best, and over the next 1 hour, my attempt is going to be simply to empower you with the necessary resources and the ideas to help you place victims in our criminal justice system, and also to highlight the barriers that they face in their quest for justice, owing to the existing theoretical framework or the foundations of our criminal justice system. In doing this, I am primarily going to be supported by two very important works by Niels Christie. He's a very noted criminologist. He's a very noted victimologist in the field. And these two works are one, Conflicts as Property, and the second is The Ideal Victim. Before we do that, however, we need to familiarize ourselves with a different but no less eminent scholar of criminal law, that is Professor Herbert Packer. I hope my PPT is visible to everyone.
Yes, it's visible.
Yeah. Okay, thank you. All right. So before we actually begin, I really hope that all of us are well versed or aware rather about Packer's two models of criminal process. Now, this is a very seminal piece of writing. Just give me a second. In case you're not aware of this, I'll just put this out on chat for you guys as well. Herbert Packer, two models of criminal process. So in case you haven't read this work of Professor Herbert Packer, I would very strongly recommend that you drop whatever you're doing right after this session and just pull up this piece which is available online and start going through the same, because this is something that is very fundamental, something that is very foundational to our understanding of the criminal justice system itself, right? So in his seminal thesis, I'll just give you a brief about it because it's kind of pertinent in terms of understanding why was there a need for us to develop an idea of victimology and then move from victimology towards victim justice, right? So in his piece, Packer essentially asks us to detach ourselves from whatever our understanding of criminal justice system itself is, and instead examine what two extremes of the criminal process can actually look like. He tells us that the kind of criminal process that we have, it essentially depends on the underlying values that the system very directly or indirectly reflects in its functioning. In identifying these values of the criminal justice system, he describes two models of criminal process. As a preface, he asks us to be very neutral observers and not judge any model, and not attach any value choices with respect to any of these models, but to merely treat them as being descriptive of what the two ends of the criminal process can actually look like if we try to normativize the same. The first end that Professor Packer tells us about is something called crime control. He says that if you try to imagine one end of the criminal justice process, what would it look like? One of its function primarily is to ensure that there is a repression of criminal conduct. Now, how does this happen? This idea of a repression of criminal conduct, this is essentially based on the idea that we can quantitatively analyze if our criminal justice system is, something that is successful or not. And what this essentially means in layman terms is that a high rate of failure to apprehend and convict can potentially lead to a lot of public disorder. In this sense, we find that Herbert Packer's crime control model, it is very similar to, or rather it is in line with the social contract theory that was proffered to us by Thomas Hobbes, John Locke, and J.J. Rousseau as well. And the purpose of the criminal justice system in such a crime control model primarily becomes the security of the liberty, the freedom, and the rights of all individuals against transgressions by another. However, to achieve this goal of repression of crime effectively, what is required is, basically efficiency, in the sense that, that what is the capacity of a criminal justice system to try to investigate and to prosecute as many individuals as possible. And the fact is that in such a case, this model should then automatically also give you a very high rate of apprehension and a very high rate of conviction. And only then will this model be considered to be something that is successful. In order to achieve very high rates of apprehension, in order to achieve high rates of conviction, what is also required are two elements of speed and finality. Speed itself requires something called informality and uniformity. Informality essentially means that you can end up using even extrajudicial processes over formal legal processes. And in layman terms, what this means is that you can prioritize and even give weightage to confessions which have been extracted at the police station. Uniformity, on the other hand, it requires that the criminal process must look like a factory with an assembly line, right? I hope you guys understand what an assembly line itself is, right? Whenever this is something that was conceived by Henry Ford, and he basically tells us that, and this is what made Ford Motors today, which is that, earlier before Henry Ford, the cars used to be made by, a single person. Every single task with respect to the car is being made by one single worksmith. But then what Henry Ford did was to specialize those worksmiths, that if somebody is going to work on the engine, only they are going to work on the engine. If somebody is going to work on the chassis of the car, only they are working on the chassis. If somebody is working on the upholstery, only they are working on the upholstery. And over a period of time, everybody gets their specialization. So this is the kind of model that the crime control model also, envisages for us, that the police only investigates, the prosecution only prosecutes, the courts only try, right, the cases. So, throughout this entire process, then you have stages in a factory. So that is how you actually ensure uniformity in your criminal process as well. It is pertinent to note here that the crime control model does not say that you can't have rules, for instance, against illegal arrest, or against unreasonable searches, or against use of coercive methods to extract confessions, but that these rules cannot stand in the way of efficiency. And this brings us to the idea of finality, which primarily means that let's say an accused who is then convicted on the basis of a confession that has been extracted, at the police station, he can't then say that this conviction is because of evidence that was extracted to me forcefully from me forcefully. Similarly, just because his arrest itself was illegal doesn't automatically make him eligible for bail. So this is the kind of what the crime control model seeks to do for us. Remember, we're not attaching any value choice to this model yet. What Herbert Packer here is doing simply is that he's telling us that this is one extreme of the criminal justice process. This is what, if you only prioritize crime control, this is what you're going to get out of a model or a system. On the other end of that extreme is something called the due process model. And this model essentially looks like an obstacle course or a hurdle race. And what this means is that each and every stage of this process is designed in such a manner that the accused is given every opportunity to prove his innocence. So what essentially happens is that if at the stage of investigation, the police makes a mistake, then the prosecution can fix it. And if the prosecution makes a mistake, then the courts can fix it. And if the court itself makes a mistake, then the appellate court can fix it. Packer says that much like the crime control model, this is also an assembly line model, but that the due process model is very wary of the methodology that is adopted by the implementers of the crime control model, that is the functionaries of our criminal justice system. He says essentially that the functionaries of our criminal justice system are humans like us. They are always prone to errors, and we must make sure that every opportunity is being given to the accused as well as to the criminal justice system to correct these errors as well. So as opposed to the functions of speed and finality that the crime control model focuses on, the due process model, on the other hand, seeks to be efficient, but it says that we can't do that at the cost of reliability. Whatever decisions that we're coming to, they must be reliable, right? So Packer essentially says that this looks like a factory as well, but a factory that focuses very strictly on quality control, even if it ends up reducing the quantitative output of that factory. So it's fine. So the idea is that in its pursuit of reliability, the due process model is grounded in the idea of individual rights and the libertarian values which support individual rights. In this conceptualization, a great amount of weightage is attached to the effects of criminal sanction itself. That is, the moment you arrest an offender or arrest an accused, that leads to a loss of liberty. And there is also a sense of stigma that comes to be attached to both an arrest as well as a conviction. As per this model, criminal law in the process is, the maximum extent of the state's coercive powers. And therefore, we must make sure that we are subjecting this to the greatest of controls and safeguards. So what I've just shared with you essentially is a very compact version of the two models that Packer gives us. And the fact is that there is a lot more to these models than I can possibly, expound in the course of this lecture today. But one of the most important critiques of this model, right, and consequently a critique of the criminal justice system that we have, is the fact that this model, it blanketly ignores victims of crime. Again, so Herbert Packer, he wrote this piece all the way back in 1967, right? It's a foundational text in criminal law. Most of our scholarship today, which seeks to question the idea of criminal processes, relies somewhere or the other on this idea of either crime control or due process. So, I mean, I'm introducing you to this piece for the simple reason that you need to understand that traditional scholarship in the field of criminal law predominantly focuses on just the accused and the state. The victims themselves are nowhere in this idea of traditional scholarship in criminal law. And the fact is that Herbert Packer was not conceiving this in isolation. This is not something that he conceived deliberately to keep the victims out. It's just that this idea that a criminal trial is essentially a two-way process between the state and the victims. This is something that is embedded in adversarial traditions, and that's a tradition that we have borrowed for ourselves. In this jurisprudence, the fact is that a crime is traditionally understood as an offense against the state or an offense against the society at large. And what happens is that the state takes over the function of investigation, the state takes over the function of prosecution and execution as well. And in order to uphold due process of law, the offending accused is given a fair amount of protections and rights against any action by the state. But you have to consider at the same time that victims in and of themselves just end up becoming another piece of evidence. In this adversarial tradition, they're nothing more than witnesses. They're just stage props. They're just theatrical aids in the larger scheme of things when it comes to prosecuting a particular offense. And this entire exercise just translates into understanding that securing justice to victims is not the prerogative of the state, but securing justice to society is something that is prioritized by our criminal justice system. So what ends up happening is that the state fails the victims twice. The first failure of the state is in terms of preventing that offense from ever happening in the first place. And the second is that the state fails in restoring the victim to his rightful position, especially in terms of their right to participation in a trial. So beginning in the late 20th century, that is the 1970s, much has been written from a victimological perspective about the removal of this injustice. Nevertheless, much of what has been written about this injustice to victims is yet to translate into laws or even an official policy of the state, at least in the Indian context. Even globally, this aspect of recognition, this legal recognition to victims of crime, it came into light only in the 1970s when a series of victimization surveys were conducted to understand the pervasiveness of victimization in a particular society. I hope you guys have heard about this term victimization surveys before. If you haven't, I'll just type it out for you, and maybe you can just run a quick Google search in order to familiarize yourself with this idea. But what essentially happens in victimization surveys is that, okay, all of us know that we have crime surveys, right? In India, for instance, we have Crime in India Statistics, which is released by the National Crime Records Bureau every year, right? But in the US and the UK in the 1970s, they conducted another set of surveys which complemented the crime surveys. And this set of surveys was called victimization surveys. And the basic idea here was to try and understand what is a victim's perception of a criminal justice system, what is in terms of the efficacy, that is how effective do they think the criminal justice system is, also in terms of how involved they feel with the criminal justice system, how much trust they repose in the criminal justice system. And the data that these surveys threw up was something that was very startling because it established in no uncertain terms that there was a huge problem of underreporting of offenses in all of these jurisdictions. These studies established that crime surveys, which were conducted in the states, they underestimated the prevalence of victimization amongst the marginalized and the vulnerable sections of the society. And what this tells us is that, for instance, victims of domestic violence or victims of sexual offenses, they're just afraid to speak up. Similarly, victims who are illiterate or victims who come from marginalized backgrounds or victims who are downtrodden, they're also equally unlikely to speak up, come forward, and report their offenses in the first place. And the thing is that this underreporting misskewed the data to the extent that if we were to go by a definition of who a victim is, as per the crime surveys alone, we would find that the average victim is somebody who is young, somebody who is male, and somebody who is poor, right? And from this entire idea of victimization surveys is where we find the first glimpse, in our talk of something called the victimological critique of criminal law. And the fact is that any course on legal aid, it cannot be complete if we were to keep the victims out of the loop completely. And this idea of exclusion of victims from our criminal justice system, this is nothing but systemic and institutional, right? And Niels Christie's work in Conflicts as Property helps us expose this institutional weakness. So what Niels Christie does is that, as opposed to identifying the issues in normative models such as the due process model and the crime control model, Christie essentially identifies the problems with the criminal justice system vis-a-vis the victim. And he does this in a more practical, in a more pragmatic sense, as well as in a more social and a holistic sense as well. So this he did in his piece. Again, I'll just type it out for you guys so that you're able to access this after the meeting. Just give me a second. This is called Niels Christie, Conflicts as Property. And this was published in the British Journal of Criminology in 1977. So you guys can always look this piece up. I believe, again, it's available online. And just in case it's not, then I can always share the copies of the same with the organizers and they can share it with you, right? So, what Niels Christie, essentially does is that he gives us a perfect segue in order for us to, allowing us to move beyond victimology and moving on to victim justice in and of itself. And Christie begins with a very provocative statement. And he says that perhaps we should not have any criminology at all. And perhaps we should abolish all the institutions of our criminal justice system. And he says this because he believes genuinely that the social implications of these institutions are much more murkier, much more suspicious than we imagine generally. The central thesis of Niels Christie in this work essentially is that conflict is something that is the rightful property of the victim that is stolen from them by the criminal justice system in general and by lawyers in particular. See, this is something that's phenomenal, right? Because whenever an offense occurs against me, for instance, and I call the police, I report that offense, my agency stops there. After that, it's the police who's going to be doing the investigation. It's the prosecution who's going to be doing the investigation. But I, as a victim, will have very little role to play after that. So essentially, the crime that was committed against me, that is the conflict that I was involved in, this was my property to begin with. But then state has come in and state has overtaken this entire property. And Niels Christie tells us that as a form of property, conflict is something that is very valuable, or rather my contribution or my participation in that conflict as a victim is something that is very valuable to me as a victim. And the problem seems to be stemming from the fact that the functionaries of our criminal justice system seem to be creating some kind of a monopoly over the criminal justice system, as against those who stand outside this justice system. In this context, in fact, Niels Christie goes on to the extent of saying that all lawyers are professional thieves, right? How contentious is that? How scandalous is that? He's calling all of us. We're all either training to become lawyers or we're already lawyers. And then Niels Christie comes out of nowhere all of a sudden and tells us that we're all thieves, right? He says, however, logically that, and this particular statement is on your screen as well. He says that lawyers are particularly good at stealing conflicts. They're trained for it. They're trained to prevent and solve conflicts. They're socialized into a subculture with a surprisingly high agreement concerning interpretation of norms and regarding what sort of information can be accepted as relevant in each case. Many among us have, as laymen, experienced the sad moments of truth where our lawyer tells us that our best arguments in our fight against our neighbor are without any legal relevance whatsoever, and that we, for God's sake, ought to keep quiet about them in court. Instead, they pick out arguments which we might find irrelevant or even wrong to use. Think about it, right? We keep using all of these terms whenever we talk about law and whenever we talk about, let's say, criminal law in general. We'll use terms like self-incrimination. We'll use terms like double jeopardy. We'll use terms, like proportionality. But all of these terms have no meaning for a general victim of crime, right? They literally mean nothing to them at all. Instead, what we have done is that we have created a very formal structure for us, which only we understand, and nobody apart from us who have trained in the field of law understand, right? And this is something that works towards excluding victims of crime in crimes in general. Think about this. Think about a courtroom setting. I think most of us are lawyers, some of us are students, but even if you've done your internships, you must have gone to courts. Imagine what a general courtroom looks like, right? So you have, you have the judge's bench, which is usually on a higher pedestal, on a higher podium. Then you have the court reporters sitting right below those desks. Then you have two desks. On the left is the prosecutor's desk. On the right is the accused or the defense counsel's desk. And behind those are rows and rows of benches on which usually it's the lawyers who are, waiting for the case to be heard. They're the ones who are sitting. Instead, the witnesses and the victims find themselves outside the court itself, right? At the end of the day, whenever a victim tries to go in, and if they do not have a proper rapport or they do not look like somebody who belongs to let's say a higher gentry, they're more likely than not to be sent out of the court because they end up in a court crowding the court itself, right? But imagine how many hurdles a victim will have to cross before he can actually be heard by a judge. So there is a formal distance that our justice system seems to be creating. And what this formal distance does for the victims is to exclude them from participating in the trial itself. So Christie then, goes on to say that the modern crime control systems, they represent one of the many cases of lost opportunities for involving citizens in tasks that are of very immediate importance to them. He further says that, and I quote, it is the crown that comes into the spotlight, not the victim. It is the crown that describes the losses, not the victim. It is the crown that appears in the newspaper, very seldom the victim. It is the crown that gets a chance to talk to the offender, and neither the crown nor the victim are particularly interested in carrying on that conversation. The prosecutor is fed up long since. The victims would not have been. He might have been scared to death, panic-stricken or furious, but he would not have been uninvolved. It would have been one of the most important days in his life. Something that belonged to him has been taken away from the victim. So think about it this way, right? imagine what is the role of a victim in our criminal justice system, in our criminal justice system, that is the Indian criminal justice system, right? Granted that in India, the victim was given the right to hire a private advocate. This was done in 2009 by the Criminal Law Amendment Act of 2009. They can hire a private advocate, but the question then arises is what is the role of this private advocate, right? And if you take a look at the Bharatiya Nagrik Suraksha Samhita as well as the CRPC, you'll find that the extent of their role is that in the magistrate's court, they can have, they have the permission to take up the prosecution, but that is only subject again to the discretion of the court and the permission of the court. But in the court of sessions, it's only the prosecutor who can conduct that prosecution, no one else. That means that the victim's private advocate, he can only work under the directions of the public prosecutor. And as per the law, the only right which the victim's private counsel has is to basically, make written submissions after the evidence has been closed in the matter. So that is about the extent of it. The best that a victim's counsel can do is perhaps go to the prosecutor and plead that, look, this is perhaps an evidence that you should be showing, and this is an evidence that you should not be giving. If a victim does not have a private advocate, I find it very hard to imagine that, I find it very hard to imagine that he will ever be given the opportunity to actually present his side of the story unless he's being called to the stand as a witness, right? And that too at the stage of either examination of in chief or cross-examination, right? So that's really just a line of questioning. He's not putting forward his point of view at all. There is no scope in our criminal justice system in terms of allowing for a victim impact report to be presented before the court. And this is something that's extremely sad, right? Because at the end of the day, it's the victim who has been impacted by that crime. Only he knows what he has gone through. I'm not arguing here at this point of time that the accused's rights or the convict's rights need to be, whittled down. But the question here is, how do you bring, or the victims to their rightful position in the criminal justice system in terms of their participation? Unless and until the victim is actually given the opportunity to present before the court what that impact, and how did the crime actually impact him. I fail to imagine a situation where victims, words can be accounted for, or victims' losses can be accounted for by the court in any significant manner. And this is a very unfortunate situation. I wrote about this in the recent, in the Indian Express, in fact, very recently, that the case of Karan versus State NCT of Delhi, where the Delhi High Court laid down a very extensive procedure in terms of victim compensation, which allowed for the courts to take into consideration the precise metrics of the losses which have been suffered by the victim into account while granting compensation. That has now been overruled by a 5-judge bench of the Delhi High Court in Saif Ali. So this is another very, a very, desolate or a very depressing situation to have arisen. In any case, the thing is that the moment we take a conflict away from the victim, the problem that then arises is that this is not just a loss for the victim, but this is equally a loss for the society, as well as the criminal justice system as well. Christie points out that the first sense in which this is a loss to the society is that the society loses a chance for norm clarification. That is, it loses a chance for us to critically examine what is the law of the land itself. Because we as lawyers, we are trained to look at very formalistic aspects of the law. We often forget to ask a very simple question. Is the law right or is the law wrong, right? Think about it. I mean, we as lawyers go to the court and we argue at the time that this is the law. right? But how many of you have actually gone on to question the rightness or the justness or the wrongness or the unjustness of that law? They also very often forget to ask the parties what is it that they actually want, or let the parties decide what is the best situation for them. And the problem is that even though there can be social and political issues which creep into criminal trials through the back door, there is very little chance left for us to address that head on if we do not give the victim a chance to participate in that trial. The example that Christie gives us is that there might be a situation where the victim is weak and the offender is powerful. Or there might be a situation where the victim is powerful, but the offender is somebody who is just, let's say, a small time thief or a petty pickpocket. How do you address the issues that work in terms of the application of law and the application of the criminal process in such cases if your law doesn't permit you to go beyond the word of the law in order to ascertain these power dynamics themselves, right? Um, a second way in which Niels Christie tells us that the victim and society are big losers in terms of the conflict is that the victim never actually gets to meet the offender face to face. And Christie says that what ends up happening is that we leave the victims outside the court without any kind of an interaction or any kind of a human contact with the offender. And when you do that, what ends up happening is that the victim ends up relying on a very stereotypical image of the offender, right? That the offender is somebody who's very big, who's very bad, and who's very powerful. And this actually is a loss for both the offender as well as the victim. By creating an opportunity for the victim and the offender to come together, there is a very positive impact to be had for all the three parties, that is the victim and the offender and the society as well. The victim will get to know the reasons as to why they were victimized, and the offender might be able to offer an explanation as to why they chose that particular person as a victim. The offender also gets a chance to repent, and the victim might be able to forgive, and the offender might be able to receive that forgiveness. But all of these conversations are essentially lost just because we end up adhering to a very formalistic application of the law, right? So, I mean, the basic idea behind me trying to push this point across to you is that that theoretical criminal justice system as a whole, this is something that ends up disempowering victims of crime. I hope everybody is able to hear me clearly. I just received a message that there's some network issue at my end.
No, it's a clear audible.
Okay, thank you so much. All right. Now, the second reading that I want to refer to you in terms of, in furthering your understanding or the theoretical understanding rather of the way our victims are placed in the criminal justice system is Niels Christie's work in The Ideal Victim. And this is something that, again, I'll just type it out on chat for you. Niels Christie, The Ideal Victim. This is something that was published in a book by Ezat Fatah, which is titled From Crime Policy to Victim Policy. And this is a book from 1986. So, essentially what, apart from highlighting the plight of the victims in the criminal justice system through the removal of their participatory rights, in this particular piece titled The Ideal Victim, Niels Christie highlights a very different aspect of the problem. And this is that of systemic and social non-recognition of victims themselves, right? So in essence, I just want you to take a look at three situations which are on your screen right now, right? You have situation A, where you have a frail 70-year-old woman who's taking care of her grandchildren while her son is at work, being mugged. Mugged, that is, she's being forced to turn over whatever she has, whatever valuables she has. She's mugged by two drug addicts at a park. They hit her in the face and then they take away her valuables. A second situation, that is situation B, is that there is a 50-year-old healthy man. He's taking a walk in the park while talking on the phone. And that is when two men on a motorbike snatch his phone from his hand. And in situation C, there is a 25-year-old man who had gone to score weed from his dealer, and he is beaten up by goons or gundas to whom he owes a very large debt. Now, try to take a look at all of these three situations in juxtaposition to one another. And my best guess is, and please feel free to disagree. And if you disagree with me, then you can always give reasons as to why you disagree with me. But my best guess here is that you all very instinctively feel that the woman in situation A is somebody who's very easily recognizable as a victim, right? She's 70 years old, so she's old. She is weak, right? And therefore she can't protect herself. She was doing something good, right? I mean, taking care of your grandchildren is perhaps the best work that you can do out there after you're retired. She was outmatched by two drug addicts who then ganged up on her. She was hit in the face, and she's the very definition of who we very instinctively think of when we hear the term victim, right? In the second situation, you have a 50-year-old healthy male who had his phone snatched from him, right? He is a victim in our eyes, yes, but he's probably not as helpless or as frail as the 70-year-old woman. And at some level, we probably feel that he could have been a little more careful, right? Maybe he shouldn't have been talking on the cell phone in the first place. Or maybe he should have been a little more careful when he was talking on the cell phone in a public place. After all, snatching is something that's very common. It's increasing in our society. So we end up thinking that he opened himself up to victimization in a certain way. He was doing something healthy, which is good, but it certainly wasn't as good or respectable a project as what the 70-year-old woman was doing. She was taking care of her grandchildren. He's just taking a walk in the park. So he falls under our understanding of a victim, but then again, we tend to feel that he's probably not as good of a victim as the 70-year-old woman. In the third situation, however, situation C, we find it very hard to recognize that 25-year-old man as a victim. He had gone to score weed. Weed or ganja is something that is illegal. So he was already engaged in an unlawful conduct. Many people consider this to be wrongfully or morally questionable as well. And scoring weed or consuming weed is generally frowned upon in our society as well. He had incurred some very significant debts, which is why perhaps the goons were after him. And he's a 25-year-old male, which means that he had the capacity to be defending himself as well. This person in situation C, therefore, he hardly falls into our understanding of who a victim themselves is. But the fact is that in all of these three situations, there was a person, and that person suffered some harm, and that person suffered some losses. But our understanding of all of these three people in situation A, B, and C as victims is something that differs very vastly, something that differs very wildly in each case. We tend to think of some people as greater victims. That is, the woman in situation A is a greater victim, but the man in situation C is a lesser victim, right? But the thing is that if you change the slightest of details in all of these three situations, you also end up changing your perception of these victims as well. For instance, in situation A, instead of a 70-year-old woman who was taking care of her grandchildren, what if you had a 70-year-old homeless man who was drunk and asleep on a park bench. And that's when two drug addicts come out and mug him and take whatever valuables he has, right? Um, we would still perhaps be sad. We'll still feel like, okay, he didn't do anything to deserve it. But at the same time, you won't feel as much of a sympathy for a 70-year-old drunk homeless man on a park bench as you would for a 70-year-old woman who's taking care of her grandchildren in a park. Similarly, in situation C, what if we tweak the facts a little and I tell you now that that 25-year-old man had gone to score weed for his ailing mother who was suffering from cancer. So many studies have shown that weed is something that dissipates the effect or reduces the effect of chemotherapy and radiotherapy in cancer patients. So he had probably gone to score weed for that reason. And that he had taken the debt from the goons in order to pay for his mother's chemotherapy. All of a sudden, this same person in situation C, who was not a victim in our eyes, suddenly becomes a victim in our eyes, right? So what's essentially happening here is that, you know, we have to understand that victimhood is a concept that can't be studied in a very objective manner. It is something that is very subjective. And it is something that has to be understood in a larger context. And this is something that our criminal laws end up completely missing out on. And this brings us to a conclusion that we consider some victims as greater victims while we consider other victims to be lesser victims. And if we have greater victims and if we have lesser victims, we must also have a conception of an ideal victim as well. So an ideal victim, Niels Christie tells us, is a person or a category of individuals who, when hit by a crime, most readily are given complete and legitimate status of being a victim. And he has in his piece very ably laid out what are the characteristics of an ideal victim as well. He says that an ideal victim is weak. He is carrying out a respectable project. He cannot be blamed for the offense. The offender was bad and powerful, and the offender was unknown. Right? Try to apply this conception of an ideal victim to situation A. The woman was weak. She was 70 years old. The woman was carrying out a respectable project because she was taking care of her grandchildren. The victim cannot be blamed for this offense, right? She did nothing to call the muggers, right? So she did nothing wrong there. She was just in a park. The offender was powerful and bad. You had two drug addicts, right? Not even one drug addict. You had two of them. And the offender was unknown. So that 70-year-old woman did not know those two drug addicts either. So therefore, you're very ably able to say that, okay, in situation A, that woman is an ideal victim. But you're not able to attach that label of an ideal victim to the man in situation C. Why? Because he wasn't weak. He was a 25-year-old man. Was he carrying out a respectable project? No, he had gone to score weed. What can he be blamed for that offense? Yes, he can be blamed because he took a debt from the goons. Were the offenders powerful and bad? Yes, they were powerful and bad, but in light of all of the other points, it hardly matters. And was the offender unknown? No, the offender wasn't unknown because he had borrowed that money from the goons who beat him up, right? So he fails on 4 accounts out of the 5 points that Niels Christie says are the characteristics of an ideal victim, and which is why in our eyes he's not as good of a victim as the woman in situation A. And the thing is that by perpetuating, whether knowingly or unknowingly, this construct of an ideal victim, what we are essentially doing is that we are creating something called a hierarchy of victimization, which essentially tells us that some victims are more deserving of being recognized as victims of crime. They enjoy a higher status as a victim, and their experience of victimization is something that is taken much more seriously than others. They get better treatment during the trial. Their rights are better enforced, and they are better able to prove in court that the offender actually deserves stringent punishment. But Such a categorization of victims as ideal and unideal often has very major impacts in the way our criminal justice system works in general as well. So the thing is that when we use the term criminal justice system, we tend to dehumanize it, right? We think of it as a system. But the fact is that a criminal justice system is nothing but something that is composed of people like us, right? You have the police, you have the prosecutor, you have the defense advocates, you have the trial judge, you have the appellate court judges, you have the prison authorities, and all of them together form the criminal justice system. And all of these are people like us. So if we, as people, are prone to creating hierarchy of victimizations, perhaps these individuals too are equally prone to be working under such a conception, right? Um, and the thing is that just like you thought that that 70-year-old woman is perhaps more deserving of a recognition as a victim, and that 25-year-old man is not. The judges, the prosecutors, the police are going to end up feeling the same as well. And what Carabine here tells us is that the police, in fact, has all the more reason to be prejudiced against the individuals or the groups whom the police tend to regulate and control more than the others, right? The thing is that it's common for the police to arrest from these classes of persons. I hope you guys have seen a movie called Jai Bhim, right? In any case, the spoiler alert, the protagonist in this movie, he belongs to an impoverished tribal community who is arrested by the police on trumped up charges and is subjected to much custodial violence for days on end until his death. His wife and relatives are also subjected to such brutality, but they're lucky enough to survive. The wife and the relatives, they have to run from pillar to post in order to get recognized as victims. And until they actually manage to find an advocate who will take up their case and then stick to his stand, there was nothing that they were able to do to actually prove their status as victims of custodial torture as well as custodial death. And the state, throughout the movie, we watch apathy in action. The state could not have cared less for their plight. The police was completely blind to their troubles. And this is something that state's own data actually tells us as well. If you take a look at the prison statistics of 2020 released by the National Crime Records Bureau, you'll find that more than 65% of the persons in prison, they belong to SC or ST or OBC categories, and almost 1 in 3 persons is either an SC or an ST. Similarly, 70% of all convicts are SCs and STs in states like Bihar, for instance, where this population is higher. And what this does is that this goes on to show that who is a victim and who is not a victim is not just a legal question or a philosophical question, but this is as much a sociological question, and this is as much a political question as well. But all this makes the recognition of victims and victimhood itself a very complex process. But here's the catch: you don't actually have to be from a marginalized community or a vulnerable section of the society in order to have your victimhood taken away from you. This can happen to anyone. A very prominent case that I can remember is that of the Arushi Talwar murder case, right? I hope all of us are versed with the facts of this case, right? Which is that there was a girl called Arushi Talwar. She was a teenager who was found with her throat slit in her bedroom and in a very prominent locality in Noida. Her parents were very reputed dentists, and they were immediately framed by the police as being prime suspects when the body of the servant was also recovered from the premises. A theory was released in the media that the father had found that Arushi and the servant were in some kind of a compromising position, and therefore he murdered both of them, and that this was a case of honor killing. The Talwars were taken into custody on such a basis. Ultimately, that case was then handed over to the CBI, who filed a closure report in the case saying that there is not enough evidence in order for us to file a charge sheet in this case. But the High Court the trial court refused to accept the closure report and asked the CBI to file a charge sheet. Ultimately, on the basis of that charge sheet, the parents were convicted in 2013 as well. They were only acquitted by the High Court in 2017, which held that the trial court's conviction itself was based on very weak evidence. And the fact is that this case remains unsolved till today. But those of us who were watching this episode unfold from very far away, we saw a shift in our allegiances, right? The media trial that happened, it actually kept us informed on all of the developments in the case. At one point of time, the Talwars were being painted as victims, and at other points of times, they were being painted as the offenders. If it was such a confusing saga for us, imagine what the Talwars themselves were going through. At one point of time, they were the ideal victims. They were parents who had just lost their beloved child and their only child. And in the next moment, they were the worst parents in the country. They murdered their own daughter. I mean, what monsters, right? As the case remained unsolved, the fact is that the Talwars are yet to receive their full recognition as victims of a crime. Even if they were, denied their victimhood when they were accused of that offense, I have come across no state action which grants them that recognition by the state as victims till date, despite the fact that they have been, acquitted by the High Court. So essentially, the point of today's lecture itself is very plain and simple, right? Which is to help you draw out a distinction of how our theoretical understanding of criminal justice system, it was conceived to cater to only a two-way conversation between the offender and the state. Our scholarship, at least till the 1970s and at least till Herbert Packer, it was also geared towards addressing this question, which was raised by this two-way conversation. And this two-way conversation was something that is completely ignorant of victims as well as their rights within our criminal justice system. And what Niels Christie's scholarship helps us uncover are two very important aspects in this regard. Firstly, that in reimagining conflicts as property, which belongs to the victim, we can establish what is the rightful place of victims in our criminal justice system. And this can help us correct the institutional anomalies that lead us to exclude victims from the criminal process as well, like including whatever legislative frameworks or whatever amendments that we need to make to our legislative frameworks. Has to be examined. It has to be studied. The second way in which Niels Christie's scholarship helps us understand the placement of victims in our criminal justice system is by accepting that the idea of an ideal victim, is something that stops us as a society, and by the factum that the functionaries of the criminal justice system are also members of the society, stops us from recognizing or giving due recognition to the victims of crimes themselves. And by making ourselves self-aware about this concept of the ideal victim, we can then move towards uncovering and then removing our collective biases and our collective prejudices that prevent us from giving due recognition to victims of crime. Right. So I believe that's my time, and I think I'll devote another 15 minutes to any questions and answers. So over to you.
Yes, participant, any question, query from your side? You can unmute yourself or put it in the chat box if any.
Good evening, sir. Yes, I wanted to know about why victimology is not as developed in the case of criminology in India when compared to the West, especially in terms of compensation. Is it because of our flaws in legal system? Deterrent way of punishment will not make good the losses and sufferings of the victim. Could you please enlighten us?
That's right. Thank you so much, Raju. So that's a very good question. In fact, why is it that the realm of victimology in India has not developed as much as the realm, as much as this realm of victimology has developed in other nations? I'll answer this query first, and then I'll move on to the idea of why the developments have not taken legislatively. To answer your first query, um, we have to understand that victimology itself is a relatively novel field, right? Um, it's only now that in India we're getting a consensus that victimology is something that has to be separated from the idea of criminology itself. Up until even a, a few years back, when I was studying criminology myself in law school, we used to be taught a subject called criminology, penology, and victimology. And the emphasis of that course predominantly focused on criminology, and victimology was just a module under that course. So it has to do a lot with how much of an importance we are giving to the idea of victimology. For today, for example, you have MSc and you have these courses in criminology. How many MScs do you have in the course of victimology? Right. Another reason primarily is that, and no, in fact, to add to that, I would like to say that it's only now that we have started introducing these courses. So at National Law University, Delhi, we have introduced a course on victimology and victim justice, and this is something that we had also taken up at Rajiv Gandhi National University of Law. So it's not that victimology is now not being taken up as a separate subject, but it's a very recent development, right? Which is perhaps why I can say that victimology hasn't developed as much, but there have been very significant contributions in the realm as well. I would recommend that you take a look at works by Professor Chokalingam in this regard, and also by Professor Dr. G.S. Bajpai in this regard as well. So both have done some phenomenal and seminal work in the realm of victimology in India as well. Now, to answer your second question in terms of why is it that victimology or victim justice has not actually translated into any legislative or official policy of the state? To be honest, this is a question that I've been asking myself for quite some time now as well. Because if you take a look at the international standards, you'll find that the Declaration of Basic Principles for Justice to Victims of Crime and Abuse of Power was something that was signed in and ratified by India all the way back in 1985 itself. So why is it that we are yet to provide any kind of a right to participation or right to access to justice in the most comprehensive substantive sense, where you're also including the right to information and the right to assistance to them as well, and the right to compensation and the right to restitution, like such basic rights? Why are they missing from our criminal justice system at all? And let me apprise you on that. It is not that these laws are completely absent or these rights are completely absent from our criminal justice system. For instance, if you take a look at the SC/ST Prevention of Atrocities Act of 1967 as it was amended in 2016, you'll find that there's an entire chapter which is dedicated to rights of victims under that particular act, and it gives them very comprehensively the right to assistance, the right to information, the right to participation at various stages of the trial as well, not to mention the right to compensation and a right to reparation as well, right? So you have all of these rights which are present in our criminal justice system. It's just that the way the conversations in our criminal justice system have developed, we are yet to take up the case of victims in a more holistic, general sense. We've been focusing too much on specific categories of victims. For instance, the Criminal Law Amendment Act of 2013 brought in the offense of acid attack, which said very specifically that any fine which is imposed under this section will have to go towards the medical and other expenses which have been incurred by the victim. It's there in the provision. It's a part of a substantive criminal law, but it's only there in the cases of acid attack victims. What about victims of theft, let's say, or what about victims of robbery or dacoity or hurt, grievous hurt, right? What about them? Do they not have the same right? Do they also not have a right generally to be able to recover compensation from the accused in the form of a fine, right? That conversation has never happened in our jurisdiction. and which is why we need to move beyond that today, and start having this conversation, start talking about victims of crime as a general unit, as opposed to specific kinds of victims of crime. Of course, within that larger framework and within that larger conversation, you can always try to identify what are the specific needs of those specific victims of crimes as well. But we need to have the larger conversation nonetheless, right? I hope that answers your question.
Excellent clarification. Thank you so much.
Right.
Sir, a question has been put in the chat box.
Okay.
What would be the position of wrongfully prosecuted victims who are released after years of imprisonment?
Absolutely. Wonderful question again, Sanika. I'm actually working on a project on wrongful prosecution as well, right? So the thing is that, again, the question is that what do you, again, you have to understand some basic concepts in terms of this before we actually move on. Like, how do you define who is a wrongfully prosecuted individual? That itself is something that is very contentious. Because all of the research that has been done in this field so far focuses either on wrongful incarceration, or wrongful convictions, or malicious prosecution, or malicious investigations, or miscarriage of justice, rather. But this term, wrongful prosecution itself is yet to be defined. In my understanding, when we're talking about wrongful prosecution, we are essentially talking about all of this. We're talking about, in general parlance, everything that ranges from the fact that a false complaint has been lodged against you, all the way up to your wrongful conviction as well, and whatever happens in between. All of this would be included in the idea of wrongful prosecution. And you're absolutely right that there is a need for us to, actually create some kind of a framework that, treats these individuals, these wrongfully prosecuted individuals, not as accused, but rather as victims of crime. What has happened so far is that it's been rather discretionary on part of the courts. And in courts, in some cases, have gone on to provide compensation. But in a majority of the cases, the courts have actually refused compensation. For instance, you have the case of Adam Bhai Sundaman Bhai Ajmeri. You can always take a look at that case, and that case is as clear as day that this was nothing but wrongful prosecution. And that man spent more than a decade inside prisons on trumped up terrorism charges. The court, he asked very specifically for compensation, but the court refused. And the primary reason that the court refuses is that if we open a flood, if we open, a general law that provides for compensation to all victims of wrongful prosecution, then we are going to end up opening a floodgate, right? You're going to have so many cases flooding through our criminal justice system that it's going to be hard for you to handle it. And that is the primary apprehension that the courts themselves have, or even the legislature itself has, in terms of and this is what is stopping, the state from enacting any law, or the courts from ruling on any judgment, or giving a general direction that you must compensate victims of wrongful prosecution as well. Of course, they have lost a lot, and these losses must be compensated. If a person goes to jail, like I mentioned, there is not only a loss of liberty, but there is a loss of a lot of other civil rights. There's a loss of your family life itself. There is a loss of education of your children. There's a loss of your employment. There is a loss in terms of your healthcare. Whatever you can provide, the kind of quality of life that you could have provided to your family. There is a loss of reputation. There is a stigma that is always attached to you moving to prison. So there are many kinds of losses that need to be compensated for when you are looking at a victim of wrongful prosecution. And in my opinion, of course, we should be addressing these cases as well. Yes.
There has been 2 more questions in the chat box, I believe. They're asking your view on reasonable accommodations to prisoners with disabilities for cases like Stan Swami, Sai Baba, etc., who have either lost their life or are severely ill.
Okay, I'm trying very hard to imagine where this question is coming from in terms of theoretical understandings of victimhood, crimes and victims in general. But Of course, I mean, I think nobody in their right mind will argue that, you know, um, if there is a need, or, if there is a person with disability who has been accused of committing an offense or has been convicted of committing an offense, then proper arrangements should not be made for their, for at least the bare minimum arrangements that are required for them to lead their life in prison in as peaceful a way as possible, in as able a way as possible. That has to be made. I mean, there's no question about that. So, in case of Father Stan Swami, I know that the state, for instance, had argued that we should perhaps not be giving him a straw to drink his water from because he suffered from, Parkinson's, if I'm not wrong, right? In any case, that should have been done. Like, there's no reason for you to oppose something as basic as that. Okay. In another statement, may I read the next question? Yeah, it says that Jerry Spence says that the accused is the first victim. How do you understand the statement? I agree completely, right? You have to understand that in our criminal justice system, it's the process which becomes the punishment, right? Because and this is why you have such stringent laws against arrest coming in, such as the DASH guidelines or the DK Basu case, right? I'm not even going on to a conviction yet. I'm just talking about an accused. Um, because at the end of the day, even if you are arrested, there is a huge stigma that comes to be attached to you. Imagine we all live in, like, let's say that I live in a particular neighborhood. If the police comes to arrest me, naturally it's going to cause quite a stir, right? We live in a country where JCB ki khudai is such a big thing that if you have a JCB running, thousands of people are going to gather to watch that JCB doing its work, right? So imagine if I'm getting arrested in a particular locality, it's obvious that it's going to be a spectacle for people. I'm a respected individual of my society. A respected individual of a society is being dragged out of his home. There's going to be stigma that is going to be attached to my person as well. And even if the state is not able to prove anything and I end up coming back home, I get bail from the court and everything, nobody is going to ever be able to look at me the same way. Everybody, when they look at me now, after I have been arrested, will look at me and see somebody who has been to jail, somebody who's been on the wrong side of the law. So there is a very strong sense of stigma that is being attached. So, I would say that yes, in that sense, accused is a victim. Also, I mean, at the end of the day, when we talk about crime control, it's not just about crime control in the sense of having legal solutions to problems in terms of offenses, right? You also have to try and understand that there are very often, that the society has as much of a role in shaping a criminal as the criminal himself, right? And by society, I mean everything. By society, I mean the state. By society, I mean the economy. By society, I mean the political system. By society, I mean everything. All of this has a role in shaping a criminal themselves. So, this statement itself, it has a lot of perspectives. It has a lot of depth to it. So you can look at it from a very, vast, from very different perspectives as well. All right. Okay.
I think we can. Yeah. Any other last question, participant, you want to ask? We are closing. Okay, so from today's session, I got for next program. So let me tell you, because on criminal law, because we are not discussing this thing like I did LLM in business law. Then people are doing LLM in criminal law. So what is criminology, criminology? So little this word, it was again never studied. But again, from last few years, obviously including today's session also, I got to know. And people, I don't know why it's not part of UG. Do you teach this some part in UG program? I don't know.
Yes. We are doing it in both LLM as well as UG.
I think if even if it's not a part of maybe we can discuss this in maybe crime too, like CRPC. Maybe we can discuss or we can get some, because this happens like 3-year 5-year code,
Yeah.
that is again issues. And then because very core thing. Okay, this is a murder, this is a rape, without any background. We keep taking these things again. This kind of mindset is necessary. What you have discussed, victim, why crime happens, and then criminology part. So that's again, I would say,
That's right.
it's faculty should again, they have to take care of this thing.
Yes,
While
sir. Good
teaching.
evening. Can I
Yes, madam.
intervene?
Yes, madam. You have 1 minute. So Dr. Ruby, she is a 76-year-old
Faculty.
practitioner, faculty, having 50
Wonderful,
years of
wonderful.
experience, constantly attending all the program. Madam, you have only 1 minute. Yeah.
Yes, sir. Only 1 second I will speak because I am also faculty of penology and criminology, victimology. So I
Wonderful.
have students from LLB 1 and BA LLB 1. So these students always they go on asking so many questions and it's difficult for me to answer because crime is increasing day by day.
Yes.
No. They will ask such questions that how will you sort it out? I said we are going to have moot courts, we are going to train you, but you be attentive. And so we
Yes.
had a competition programs for them, gave them cases to study and come out with the practical training like moot court, So some of them have won also these competitions. They have been arguing very nicely. They are
Wonderful.
coming up very nicely, sir.
That's
So with
wonderful to hear,
modern
ma'am.
technology, they are thinking in the, as we are saying that we are to work for the society, we are working for last 25 years for the society, giving back to society everything as it should be normal as we are in the society. We are trying our level best and this coming up generation is damn smart. They know how to tackle and how to use this new technology and words and everything.
Absolutely right,
So,
ma'am.
sir,
And
Amit
your
sir,
work is an
Ankit sir, thank you, sir. Thank you, Kalpesh ji. Yeah, God bless you all
thank
so
you,
much.
Dr. Ruby. Thank you for being an inspiration for us.
Thank you, sir. God bless. God bless.
So madam is constantly attending all the programs,
Oh,
right?
wonderful.
For last FDP, so 7 days program, all program I would say. Hardly I would say. So it's a
I
great
don't miss
inspiration.
anything. I don't like to miss any resource person because they are also putting in efforts to collect all data and information they're sharing. It is not that easy.
Yeah,
Not
but
that
like
Absolutely.
easy.
young student and faculty member, student, they should understand because it's very
Yes.
difficult. Faculties, look at this. Like they're sitting in office. I have seen most of the faculty members. They are in the office at this time, right? Including like you can say Ankit. They take the session, then go for home. So because it's very difficult, but they should understand, take the maximum benefit. So
Nay,
that is the
but
idea.
like, ma'am, we're all doing this just because we understand that throughout life we are just students.
Yes.
We're all just students at the end of the day.
Yes. Yes, sir. Thank you, sir, giving me opportunity to interact. Thank you,
Thank you so much,
Sitara.
ma'am.
I'm missing you. I didn't hear you. Kalpesh I mean, Ankit sir,
Thank you.
thank you so
Thank you.
much.
Thank
God
you.
bless everyone. Everyone.
Yes. Over to Sitara.
Thank you, sir. And on the behalf of everyone here today, we sincerely thank you, sir, for sharing your invaluable insights and expertise on victims' rights here. And it was honestly enlightening and thought-provoking because it honestly helped us realize the crime from a victim crime perspective, which is normally not dealt with even in our classes. And we truly appreciate the time and effort that you took to be with us here today, sir. And I express my sincere thanks to Kalpesh sir and Hardik sir for organizing sessions like this, which provides us with the opportunity to engage with experts and gain deeper insights into crucial legal topics which are not being discussed in day-to-day life. That's it for today. I sincerely thank everyone and have a nice day.
Okay. Thank you, Siddharth.
Thank you. Thank you.
Thank you, sir.
Thank you. Thank you. Thank you. Thank you, Sarah, and thank you all the partners for joining. See you tomorrow. I'll be taking session tomorrow on RTI, so do this for information. Thank you. Good night.